So we all know that when the United States Supreme Court wants to act, it can do so rather quickly. It is very telling that the Supreme Court has not reached any decisions yet on some of the major cases affecting our democracy. The Fisher case involving the obstruction of official proceeding charge that was used to prosecute many of the most violent and dangerous insurrectionists, and two of the counts against Donald Trump involve this obstruction of official proceeding charge that is being challenged before the United States Supreme Court, that they took this term. And also, the Supreme Court has not ruled yet, even though many expected a ruling could come at the end of last week, on the issue of absolute immunity, where Donald Trump is asserting that he could order SEAL Team 6 to kill his political opponent, and he can do whatever he wants just because. No ruling on that. So what does that mean that the Supreme Court has not reached a ruling on that? Is that unusual? I want to bring in Mike Sachs, Senior Advisor to Court Accountability. Mike and I actually went to Georgetown Law together. He's now also a correspondent here on the MeidasTouch network with a focus on the Supreme Court. Mike, welcome to the network. Welcome to the show. What do you make of the Supreme Court not ruling on those key cases affecting our democracy, and whether we are a nation where no one is above the law, or whether the Supreme Court's going to embrace dictators in the United States of America?
Well, first, Ben, thanks for having me. And what we can read, at least from the delay in the Trump immunity case, is that the Supreme Court and the justices he appointed, as well as those that were appointed by Republican presidents before him, are shielding him from accountability for his alleged crimes against democracy on January 6th. There's no other way to read this, because the Supreme Court has chosen to delay at every single turn on this immunity case. Because let's remember, Trump's immunity argument that presidents are immune from whatever crimes they may be alleged to commit while in office is a risible claim he only brought up in the district court in Jack Smith's prosecution before Judge Tanya Chutkan. He only brought that up as a delay tactic. He knew that Chutkan was going to laugh it out of court and throw it out, and she did in quite short order. Immediately from there, he appealed to the DC Circuit, which he thought would probably take a short time to get things done. So that had Jack Smith then going straight to the Supreme Court in December, saying, please take this case. Please put this to bed if you're all taking this seriously, and say there is no presidential immunity, so that the trial, which was slated to begin on March 4th, can get on track to conclude before the election, so that the American public can understand and know who they're voting for, and that person's felonious or non-felonious status, whatever a jury would decide in this case, a jury of the president's, of former president's peers, if you will, in DC. The Supreme Court at the end of December said, nope, we're not going to take this case quite yet. They denied what's called certiorari, means they're not going to take the case. They can choose the case they want to take. And they sent it back for the DC Circuit to consider it in regular order. The DC Circuit had expedited the case. They heard oral argument in January. 2 Democratic appointees, 1 Republican appointee. The Republican appointee is quite right-wing. So if anyone was going to rule for the former president's immunity claim here, it would have been her. While the case is pending for decision, Judge Tanya Chutkan of the DC Circuit, of the Federal District Court in District of Columbia, put off the trial date, said March 4th is just not realistic. I'm going to postpone until we have better clarity on when this is going to get back to me. And then early February, DC Circuit comes down with a decision, unanimous against Trump's claim of presidential immunity for criming while in office. And 57 pages, bulletproof reasoning, no dissent from anybody. And then, knowing that this was a delay tactic, Trump would otherwise have had like 2 months or so to go to the Supreme Court to ask them to review. They said, we're going to put this decision on hold. We're not going to send it back to the district court until the Supreme Court says whether they want to jump in. But Trump, you have a week to go to the court about it. Run, don't walk. So Trump ran, didn't walk to the Supreme Court because he wasn't permitted to walk. And as soon as he goes in asking, can you please review this? Jack Smith came in and said, you don't have to. They've spoken. DC Circuit's spoken. You had your regular order, Supreme Court. Now just let the trial go on. The Supreme Court waits an additional 2 weeks. At this point, it's late February, February 28th, to announce that they are taking the case. They are going to pick it up, and they are going to review the DC Circuit's opinion denying immunity to former President Trump for his alleged crimes while in office related to the insurrection on January 6th. And not only do they wait to take the case up, not only did they deny to hear it in December when they could have put it to bed, not only did they wait to actually grant the case till the end of February, but they place it for the day after the final day of oral arguments in the term. They tacked on an extra day at the end of April to hear argument. And if you listened to the argument as I did, it was astonishing. It was jaw-dropping. 5 of the justices expressed either sympathy for Trump's claim of presidential immunity, questioned Jack Smith's appointment's constitutionality, and also said maybe it's better off that we send this case back down to consider whether we should, whether Trump should have immunity for private acts versus official acts, and if he has immunity for official acts, whether his trying to overturn the 2020 election was an official act that he could be immune from criminal prosecution for. So the way it was looking coming out of oral argument was that these justices not only weren't concerned about the biggest cataclysm to our democracy since the Civil War, but also seemed to think that a bigger cataclysm could happen in the future if they didn't rule for former President Trump's immunity claim. So we were getting delay out of the oral argument. We knew pretty strong sense that this Supreme Court, at least 5 of the justices, Roberts, Thomas, Alito, Gorsuch, and Kavanaugh, would all send the court back down for further deliberations by Judge Chutkan of the DC Circuit, which would very likely have pushed the case beyond its ability to be tried and submitted to a jury for a verdict before Election Day. The fix was in. Even if they had ruled by, say, May 20th, which was 25 days from the point of oral argument, which was the outer bounds to get the case back to Judge Chutkan to get her case back on track, the trial back on track, and also the amount of time it took for the justices to decide the Colorado ballot access case that came to them earlier. Remember, Supreme Court of Colorado threw Trump off the ballot there, saying he was an insurrectionist under the definition of the 14th Amendment, which says that insurrectionists are barred from holding public office. Supreme Court took that case up and put Trump back on the ballot in Colorado and therefore in the rest of the country as well, if any other state tried to take him off. So that was one big win for Trump before the court. In 25 days, they interpreted a heretofore uninterpreted part of the Constitution in 25 days. They also interpreted it poorly. They did not use originalism as they say they would, and they gutted this provision of the 14th Amendment, but so be it. This is a much easier case, open and shut. There never has been, nor should there be, presidential immunity from criming while in office. Every other court that took it, every other judge that took it understood this. Everyone knew, including Trump's lawyers, that this was a delay tactic. And this Supreme Court, at least 4 who chose to take the case, and the 5 at oral argument that we heard crediting this argument, were all in on the fix to delay this. And that the opinion didn't come down by May 20th, which still would have delayed the thing because of how they would have argued, how they would have ruled, and how they're expected to rule. But that we're still waiting for it now shows that there's something fishy going on back there that cannot be attributed to simply wanting to get the law right, but also looks very much like they're trying to protect a co-partisan who's trying to get back in office to run the country the way that perhaps they might want it to run, and perhaps to replace them with sympathetic successors should a couple of them, like Justices Alito or Thomas, be ready to retire under a Republican president.
So almost regardless of what their ruling is, by going through this course where they rejected at first Jack Smith's expedited briefing in 2023 on the issue, but then accepted it on a delayed track when it came in through a stay request. They kind of backdoored it in from Trump in 2024, elongated the schedule, delayed it. They've already, in essence, afforded a type of immunity that no other litigant would ever have in any case, regardless of the ruling. They've created a de facto immunity based on delay from a criminal trial. And now they haven't, and now they still haven't made a ruling. Are they, Mike, are they technically extending the term? Aren't decisions usually in by, is it unusual that this may go into potentially late June now, July? Did we expect that it was going to happen on Friday, and it didn't happen on Friday. And then also they haven't issued the decision on obstruction of official proceeding, which are 2 counts. Are they just going to do next Friday a 1-2 dump of like these horrific cases and then say, see you later, we're going on vacation? Alito's going to go to Italy and talk smack about America. Clarence Thomas is going to go on cruises with his billionaire friends. Is that what's about to happen?
Well, you touched on a couple of things I also want to touch on in these cases with Alito and Thomas and their conflicts of interest, their appearances of bias, and their refusal to recuse from these cases when their votes might have actually been might have been dispositive to the courts taking the case in the first place, and could very well be dispositive to Trump's winning these cases, again, despite these 2 men's conflicts of interest and appearances of bias. But to your timeline question, the court leaves its biggest decisions always to the end. They're a bunch of, they're divas. They like having the drama, and they leave the biggest decisions till the end of June or early July. The general rule is not a rule, but the general tradition is they want to get out by July 4th. Often that means the very end of the last Thursday or Friday in June. Sometimes it might go into July. They issued, I think there's about a dozen decisions left. They issued 4 or 5 today. There are about a dozen left. They have an opinion day slated for Wednesday, and I'm sure they will add Thursday and Friday too. So they could clear the slate by the end of next week. Very well could. Or if it has to go into July 1st or 2nd, they'll do that as well. So there's nothing fishy per se going on with how long it's taking them to get these big decisions out in general. But for the immunity case, again, the court knows how to act fast when it wants to act fast. Bush v. Gore, 1 day from oral argument to the decision. The Nixon Oval Office tapes, which pretty much condemned President Nixon and assured his impeachment and conviction before he resigned, was a couple weeks. And again, the Trump ballot access case earlier this term was 25 days. The court can act quickly when it wants to, when it feels like it has to or needs to. What we're going to have now, and you mentioned again the obstruction case, which isn't specifically about Trump. It comes from January 6th defendants, but Trump's been charged with 2 charges that are related to the ones that are being challenged in the Fisher case. That's the name of this case before the court. That case and that every other case is taken to the end of the term isn't all that surprising. But Trump's looking to run the table. He's looking to run the table in this, and he very well likely may, both in the ballot access case earlier this term, in the immunity case, which he's already pretty much won out of delay alone, and then in the Fisher case. And this case is about whether the obstruction of official proceeding charges, should apply to people who tried to get in the way of the certification of the Electoral College on January 6th, 2021. The defendants' arguments are that this law was passed to prevent things like the Enron case, which is witness tampering and evidence tampering. That is what the defendants argue this statute was designed to protect against. But as any good textualist would tell you, when they want to be actually good textualists, which was Scalia's championed way of reading statutes, was that it doesn't matter what the intent of Congress was, or the background of Congress, the legislative history of Congress is choosing to pass these laws, but what the text itself says. And the text of the statute to which former President Trump was charged, and the text in which these January 6th defendants that are challenging the statute were charged, the text is clear. This was an official proceeding. They obstructed it with corrupt intent and all the like. And the Supreme Court, at oral argument, seemed to incline to think otherwise. They seemed inclined to side with the defendants here. Again, this is the right wing of the court doesn't often side with criminal defendants, especially Justice Samuel Alito, who's never liked any criminal defendant until he's met the ones that are before him related to the insurrection. So Trump could very well benefit from the windfall from that case, having a couple of the charges against him from Jack Smith dismissed. Of course, then, though, that trial itself may be in danger, given the timing of the court's decision. And again, if Trump wins the presidency this time around, he will surely shut down that prosecution. Or if he's convicted after in the lame duck period, then he will surely pardon himself. And then they'll come to the Supreme Court, whether he can, and whether or not the Supreme Court says he can, Trump won't care. Who's going to enforce it? But one thing I want to mention, Ben, before I go forward, is the appearance of bias, the conflict of interest, of Alito and Thomas. Remember the upside down flag on Alito's property and the appeal to heaven flag, which they say was a George Washington thing, but query when people started hanging that flag and who was hanging it. And you'll notice that it has a very strong correlation to when Christian nationalists adopted it for their own position in the waning days of the Trump administration, if not even a little bit earlier. And Alito can blame his wife for this, but he saw what was going on his own property. We've heard the recordings of his talking to Lauren Windsor and in a undercover recording of his saying that he believes one side or the other has to win, and he's on board with this sort of moral struggle for America's moral center from the Christian nationalist perspective. And then you have Justice Thomas, who's taken millions of dollars over the course of his career from right-wing interests that are before the court, and whose wife, Ginny Thomas, was integrally a part of the Stop the Steal movement throughout the states, and the rally that ultimately ended in the insurrection and at the Capitol, the violent one that killed some people, if you don't recall. So you have these justices who have an interest or an appearance of bias or conflict of interest in how these cases turn out. And they're sitting in judgment regardless. And their votes might be dispositive on how these cases come out. It's no good. It's rotten. And it isn't good for our democracy when someone who tried to overturn it is seeking the benefit of this court, which has already so undermined democracy with many of its other cases, seeking the protection of this court to shield him from accountability so that he may then win and return to office to further assault our democracy.
You know, one of the things we talk about a lot on this network, I'll conclude with this thought, is how a lot of the right-wing infrastructure actually appears to be a response to Richard Nixon getting caught for his corruption and forced out of office. Both the creation of right-wing media and Roger Ailes' memo about creating a propaganda media network to combat objective truth from the Fourth Estate is directly related to Nixon. He just found a benefactor in Murdoch and was able to create Fox. What's interesting here, as you reference Nixon, is the Supreme Court looking back to some of its quicker decisions, including the Watergate tapes, historically, when it had to act for the benefit of democracy, and learning all of the wrong lessons and saying, you know what? What if we didn't do that quickly? What if we just expanded it? Maybe there would be a different history. Maybe the way the jurisprudence happened those 20 years where there were more freedoms being restored to people. Maybe there could have been differences if that didn't happen to Nixon. And so, it's an interesting thought to think about, but I think it's important that the work you're doing at Court Accountability is important that we share that here on this network, and we're going to have you come back and give more takes on what the Supreme Court is doing. And so great to have you here on the network. Thanks for joining us.
Thanks for having me, Ben.
All right, everybody, hit subscribe. Let's get to 3 million subscribers together. Thanks for watching.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.